Good morning to you all, and it's a great pleasure for my team and myself to present to you this morning specifically on the amendments to the Compensation for Occupational Injuries and Diseases Act. This is going to be a three-part series that we will tackle, starting, as I've said, with COIDA, and then in a second and third chapter, we will be dealing with the proposed amendments to the Occupational Health and Safety Act, and thereafter select topics relating to the Mine Health and Safety Act and its regulations. I have with me two of my team members, Khadishu Pashe and Byron Medisa, both of whom are going to tackle aspects of a very important regulation that will sit alongside the amendments to COIDA, which deals with the rehabilitation of employees that are injured at work, or ill at work, and the return to work program. This is fundamentally a change to how we deal with incapacity-related cases under the Labour Relations Act, and it will also bring you into a debate with regard to not just the issue of dismissals, but what about employment equity and disabled persons obviously being front of mind in the new sectoral targets that are being proposed for the purposes of the employment equity legislation. So I do want to say right up front, congratulations to Khadishu on his appointment and promotion to senior associate. Well done to you, and Byron for his sturdy work right throughout this last year. And I know they're going to be very entertaining and you're going to enjoy what they have to say. The whole purpose of the series we've put together is to challenge your thinking. It's not really good enough to sit back and say, well, the amendments aren't in force and effect yet. I've got time on my hands. I'll worry about it when it happens. No. One needs to start engaging with these changes. How will it impact your business? How have other employers dealt with some of these issues in the past? The case law speaks to that. And in fact, some of the amendments to COIDA can be traced back to previous cases right the way through our various courts that have pronounced on really complex issues. So that's really where our focus is this morning. And so I'm going to tackle the first aspect. Firstly, I want to look at some of the definitions. And one of those is the definition of an accident, which is now to include an incident or occurrence which arises out of employment and during, obviously, the employee's course and scope of employment with the employer, and which has resulted in an injury, illness, or disease of an occupational nature. Now, firstly, when it comes to whether or not there's been an accident, there has to be an employment relationship. And in a case that does go back a few years concerning ER24 and Smith, this was the very issue that was under consideration, because this young lady, Romy Starasek, was injured in a very serious motor accident. She was a passenger in a vehicle driven by a full-time employee and paramedic in the employ of ER24. Romy was a volunteer worker. She was not being paid for her services, and she signed an agreement with ER24, which specified that she wouldn't be treated as an employee and she'd receive no remuneration. When this accident occurred, and it was very, very serious, a curator was appointed to her to manage a claim as a consequence of this accident. She was a volunteer worker in the sense she was receiving training because her intention was to become a qualified paramedic. Hence, she was gaining, if you like, on-the-job experience. And ER24, when it was met with a claim for over 7 million rand as a result of this accident, then sought to raise the claim that she would be covered under COIDA and therefore would not be in a position to institute a delictual claim against ER24. Now, to cut a long story short, the issue was whether or not she was an employee. And I've mentioned to you that there was an arrangement whereby she was not to receive any income. And the judge said in that matter, because it went as far as our Supreme Court of Appeal, that the parties had rightly not raised the issue that the definition of remuneration includes payment in kind. Now, if she's a volunteer worker, she's not earning any money. How are you going to bring her within the construct of an employment relationship in order to rely on Section 35 of COIDA? And what that section provides is that if your claim lies under COIDA because your injury in this instance arises from an accident in course and scope, you wouldn't be able to sue your employer on a delictual basis for damages as a consequence of this incident. And the judge said, but if we're to look at whether she's an employee or not, then we have to examine what was the issue with regard to the value that she brought to the table in terms of furthering the employer's business. And the judge said it would be impossible to determine this in this particular instance because the value of her service was never objectively quantified. And more importantly, ER24 wouldn't be able to rely on the bar under Section 35 because it wasn't treating her as an employee and it wasn't paying any assessments in respect of her service to the compensation fund. And you might say, well, this sounds all well and good. Are there any amendments that might talk to this, which might change this position? I would argue that this case still obviously requires that there be an employment relationship. But one thing the amendments do in Section 25, where an accident arises as a consequence of training or the performance of emergency services, it does allow for the employee who's injured to claim if in undergoing any work-related training in pursuance of the employer's business, so says the amendment, this would be deemed to have arisen during course and scope, but you'd still have to have the employment relationship. Now, allied to this is a very interesting decision that's just come from our courts in 2023. And it's a decision where the employee was injured at work as a consequence of being asked to perform certain work on equipment for which they were not trained. So the employee had put up some resistance to this because he said, I've never been trained on this equipment, yet I'm expected to manage this particular task and I'm concerned about it. And there was also the threat that if he didn't follow instructions, he might actually be disciplined and dismissed. So he performs this particular function on a piece of equipment that's unfamiliar to him. He is badly injured and he wants to sue his employer. Nobody really took issue with the fact that this particular employee's employer was a labour broker, now defined under the amendments under COIDA as, of course, the Temporary Employment Service. So if one looks at the definition of an employer to include the one that is indeed in that test relationship with its client, then it calls into question the deeming provisions that we have seen operative under the Labour Relations Act and which gave rise to the decision by the Constitutional Court in Assigned Services versus NIMSA that this is a deemed employee of the client. And nobody thought to raise that as the possibility to avoid a civil claim for damages in these circumstances. But having an employee on your line who is not trained for the equipment to be used is a very dangerous situation, of course. And the cross-examination in that particular case was really quite intense because the cross-examiner got the main witness for the client to, in fact, admit that disciplinary action would be taken if the person didn't perform on that line, even though they were not trained to do so. So it does point to certain problems when it comes to, are we dealing with an employment relationship, ER24, and this case involving the company called Bentelia. I think it questions one as to what is the relationship with some of these contractors one deals with. And if it is a test relationship, well, shouldn't the deeming provision that we have seen operative under the Labour Relations Act, the Employment Equity Act, equally have application in relation to COIDA? I leave that thought with you. My next topic that I really wanted to cover has to do with one aspect from ER24, when ER24 got Romy to sign up for a contract that said no claim for liability against us. The particular provision was so badly worded that the judge said it was impossible to give force and effect to those provisions in an attempt by ER24 to avoid liability for the claim at hand. But I do want to draw your attention to section 33 of COIDA, which, although it's not the subject of any amendment on this round, it does, of course, say that an employee that is forced to sign an agreement whereby they relinquish any of their rights under the legislation is void. And that issue might well have visited that ER24 case, but for the fact the clause anyway was deficient simply because it was vague and embarrassing. The definition of a dependent of an employee is worthy of consideration because it's now talking to the dependent, particularly in relation to the death of the employee. What happens if they are receiving tertiary education? So if the child is under the age of 25 receiving tertiary education, they're considered to be a dependent. But a child who's over the age of 25 but is financially dependent on the person who has passed away, that gives rise to that person potentially receiving a share of compensation under this legislation. But please bear in mind that that does rest with the discretion of the Compensation Commissioner. And it'll be interesting to see how he deals with the de facto, de jure dependents many of you will be familiar with when you're dealing with that very concept for the distribution of pension benefits where a person has passed away, for example. Another important aspect, or definition at least, that I want to alert you to is the one concerning occupational disease. What is now going to be included is reference to post-traumatic stress disorder. And in a recent decision that many of you might recall that involved Media 24 and Grobler, the case in question was as a consequence of the employee having been sexually harassed at the workplace. The harassment to a very large extent had taken place after work hours. It had occurred other than in the workplace in some instances. And this particular lady, Grobler, suffered extensive, what the judge called extensive post-traumatic stress disorder. And her claim against Media 24 was for damages as a consequence of these acts by an errant employee at a senior level. Please bear in mind this decision was decided before aspects of our employment equity legislation came to the fore. But this was a civil claim for damages, and Judge Farlam in the Supreme Court of Appeal had to tackle this issue because what Media 24 did was try to raise the issue that any injuries sustained as a consequence of this behaviour would fall within COIDA, fall within the parameters of Section 35, no claim for civil liability against the employer. But Judge Farlam was having none of it. His attitude was, if one looked at where a lot of these particular issues had arisen, it hadn't been in the workplace, it had been outside of that. And he said, as has our Constitutional Court on occasion, there's no bright line test when it comes to cases of this nature to determine is the person in course and scope of employment or not when this injury or occurrence occurs. And the inquiry is always, he said, whether the statutory requirement that the accident arose out of the person's employment as well as in the course and scope is satisfied. The court, he said, must analyse the facts very closely to determine whether on balance the accident arose out of the person's employment, and in the last resort, the employer who's seeking to rely on Section 35 bears that onus in particular. Now, the only connection, Judge Farnham said, existed in this matter between not only the incident but also when this particular harassment occurred, was that on one occasion only she'd been at the workplace. For the rest, as I said, it had been outside of that, and the incident bore absolutely no relation at all to the person's duties at the workplace. And so he said Section 35 doesn't assist, and Grobbler's claim in our law of delict was good, and she was awarded eventually in this matter 750,000 rand, bearing in mind that that is a decision that went back a few years. And it also is an argument that was raised by one of the government departments relative to a lady called Churchill, who was injured as a consequence of protest action at the workplace. The fact that it happened on the workplace is one thing, and there was some comment about whether the employer had taken steps to ensure the safety of its employees in such circumstances, but this lady was assaulted and was driven off the property by the protesters, and the question was whether she had a delictual claim or whether the employer could argue the Section 35 bar was applicable. I don't need to tell you that the employer failed in this instance because it hadn't ensured the if I can put it this way, the legal obligation to make sure its employees were safe at work. And the steps that should have been taken that were not taken, but Section 35 wasn't going to eliminate the delictual claim. Those are, I would like to say, some good examples of what happens in understanding that bright line test. Having said that, I want to look at another definition and the following change to COIDA. You will know that if an employee has been involved in serious and willful misconduct at the workplace and suffers an injury as a consequence, then what happens to their claim under COIDA? Under the legislation as it currently stands, that can be a basis for exclusion. That has been removed from the COIDA amendments. And although those amendments are not in law yet, obviously the date for the implementation of those amendments is imminent. But what you need to do in understanding that that willfulness at workplace doesn't exclude the claim, under Section 26 of COIDA, there is a discretion which the Commissioner has. And that is, if there are special circumstances, the Commissioner may refuse or reduce an award for compensation. And the examples that are listed include where the employee makes a false representation, for example, about the circumstances which have befallen them. And that might be a basis for the Compensation Commissioner to come in and say, I compensate? Am I satisfied that this is a valid claim under the legislation? We also have to look at another particular provision in COIDA that deals with transportation to work. I think this is a very important, useful and commendable amendment to COIDA. And I would refer you to sections 22, sub 5 and sub 6. And it has to do with the conveyance of employees to the workplace. So in long distances that some employees have to travel in order to reach the workplace, they are on company-provided transport, either through a contractor or the employer's own transport. And there are pickup points for when the person boards the bus, for example, to get to the workplace, and they get taken back after hours when the shift is over, back to that drop-off point. That section of the journey is now to be considered to be in course and scope of employment, such that if an accident happens, a compensation claim would lie under COIDA. And so it's taking away some of the difficulties that have been experienced with regard to the tension between, do I have a COIDA claim or is my claim under the Road Accident Fund? Obviously, where the employee travels independently to reach that place, that pickup point, that of course is not in course and scope. Another interesting facet to these amendments is, of course, what happens where you have an employee that is working abroad for you. It might be on assignment, they might be seconded, they might be there for an appreciable period of time for a particular project, and they meet with an accident. What is the compensation payable in those circumstances? Well, here the Compensation Commissioner can relate the earnings of the person as if they were earned in South Africa. In other words, it's not going to take into account a dollar-based remuneration structure. It'll be reliant on what would the person then have earned had they done these particular or carried out these functions in South Africa, independently of having been abroad. I think that's a very useful amendment as well. Another aspect that we do need to take account of, and I'm mindful of my time here, penalties for failing to notify the Compensation Commissioner of an accident. You know that there's a time period within which that must be done, 7 days. And of course, there's also the requirement that the employee must tell you the accident has happened if you're not already aware of it. And that failure in these circumstances is quite high because previously the fine structure has been very low, both under the OSH Act and this. It's now 10% of actual or estimated annual earnings for that year. So that could be a significant amount of money. These are just some of the amendments we want you to grapple with. Most importantly now is the issue of the return to work, the rehabilitation of an injured employee, for which I would like to hand over to Khadisha Pashe. Thank you.
Thank you, Fiona. Thank you for giving us such an insightful and helpful introduction to exactly what these COIDA amendments what changes these amendments will bring and how these will affect employers. And what I'll be looking at is this new introduction of rehabilitation, reintegration, and return to work. So it's clear that the purpose of adding such a provision to COIDA is for employers to then consider how can we rehabilitate and reintegrate persons who have been injured or that have diseases during the course of employment. How can we bring them back into the labor force? So what I'll be looking at is exactly the purpose of this new Section 70A. That's what I'll be calling it, and exactly what it entails. I'll also be looking at what type of rehabilitation are we talking to here. We'll be looking at the employer's obligations in terms of rehabilitation. We'll be looking at changes that you need to make in terms of your policies or your incapacity programs and policies, and who bears the costs of such rehabilitation. So those are the things that we'll be looking at. Now, just as a start, it's very important for us to consider the position that we are pre these amendments. As it currently stands, is that an employer has to make reasonable accommodation for persons who are injured on duty. And obviously this includes instituting your ordinary incapacity procedures as per your policies. However, now this new amendment incorporates this issue that before you think about just dismissing a person, you need to consider these regulations. And these regulations, as I've mentioned before, prescribe how exactly you should rehabilitate and seek to reintegrate persons back into your workforce. Now, as a point of departure, I'd like to just even mention that this new act is the heading, or rather, not new act, but this new section, the heading of it is Compensation Fund to Provide Rehabilitation. And what this means, it says the employer and the compensation fund must provide facilities, services, and benefits aimed at rehabilitating employees suffering from occupational diseases or injuries. And this is so that they can reduce any disability resulting from their injuries or diseases. Now, one thing that I really want to highlight to you is who are the responsible parties that are being mentioned in these regulations. And from what we see here is, number one, the compensation fund. Number two, the licensee, if there is one, and the employer. Now, they together shall provide facilities, services, and benefits aimed at rehabilitating employees who are suffering from occupational injuries so that they can return back to work. So that's the aim, that's the goal. And it'll be very interesting to actually even highlight that the requirements are not for you to guarantee that you will bring back a person back into your workforce or into the labor force. However, your aim should be to bring them back to work. Another important thing is that this has to be done with the consent of the employee. So the employee has to consent to receive such rehabilitation and to participate in such rehabilitation programs. Another interesting thing which is being introduced with regards to these regulations in Section 70A is that there will be a disability case manager. Now, this will be very similar to a CCMA case manager. However, this disability case manager will ensure that the employer is actively facilitating how they can be returning, or how can they be assisting an employee to return and be reintegrated back into their work. So we can see there's a lot of practical implications in terms of what new structures will be in place and who will be required to do what. And the fact that we have a disability case manager shows you how the compensation fund will be the custodian of this program, or these rehabilitation programs. Now, the question you're probably asking yourself now is like, what are then the requirements for enrollment into this rehabilitation and reintegration and return to work program? Now, firstly, in order to be enrolled, the employer and the health care provider shall notify the compensation fund of the need to enroll an injured or diseased employee to their rehabilitation and return to work program. Now, that's the first thing that you have to do. You have to inform the compensation fund. Now, secondly, the test that needs to be passed is that the injury, as Fiona mentioned, has to be one that was born out of your course of work. And the liability from the injury is one that has to be duly accepted by the fund, simply because it happened while you were in your course of employment. That's the second requirement. Now, the third one, which is more onerous, states that the injury has to be severe and classified as a disability as per the characterized diagnosis of the compensation fund. And I guess that's where we'll get to see how it actually plays out in practice, because as we all know, there are many diseases that exist and many injuries and disabilities that exist. However, it's clear the regulations state, and this regulation 3 states that it has to be classified as a disability as per the characterized diagnosis of the compensation fund. So then it takes the determination of what this disease is or disability is, and it puts that at the door of the compensation fund. Now, it's also very practical to just highlight what an employee has to do in this instance. And again, this will go back to what I'm going to discuss a bit later regarding policies and how you have to change and implement policies in anticipation of complying with this. Right? Now, an employee must report the injury as soon as practical after the injury or diagnosis to his or her immediate supervisor or health and safety rep. Right? It goes back to the ordinary processes of reporting in terms of COIDA. And then secondly, these regulations oblige the employee to supply any relevant medical reports that they may have heard privately in an attempt to receive assistance for an injury or a disability that they may have. And lastly, is that they are obliged to avail themselves to actively participate in the implementation and the rehabilitation and return to work. Now, what is more important, and probably what you're here today, what you want to hear is, what are the obligations for you as an employer? What obligations are put on you and what you have to do? Now, the regulations are very clear in that they state that an employer must facilitate access to rehab for the occupationally injured person or disabled person. Now, again, it's very clear you must facilitate that access. Again, it's not saying that you have to provide every single thing, but facilitate that. And that's where compliance is going to come in. The question you'll be asked is, how did you facilitate this access? So then you're wondering, okay, then how do you do that? The regulations are very helpful. They go further and state that you need to establish and maintain a system of rehab and return to work reporting. So in essence, in ordinary terms, what this means is that you have to have a procedure, a process that clearly states this is what happens when a person is injured on duty. And this is how we will seek to achieve their reintegration and rehabilitation back into the workplace. There has to be a system. You need to be able to show to the department and the compensation fund that, look, we actually have a system of how we are dealing with this. And that system has to facilitate access and assistance to enable the disability case manager to also perform their functions. So that system will work hand in hand with what the disability case manager will be doing. Now, the regulations go further to state that an employer has to develop and implement a rehabilitation, reintegration, and return to work policy and program. Now, as you're probably thinking, this will largely affect your current incapacity procedures that are in place in your business. And I'll get back to exactly what this policy should look like, or at least what the regulations suggest that your policies should include. Another aspect or another obligation that is put on you as the employer is to provide reasonable transitional or temporary work to allow the injured employee to work safely during the return to work process. Now, again, this goes beyond what we've had before, in that you are obliged to provide reasonable, transitional, or temporary work to allow the injured employee to work safely in the return to work process. So again, all of these terms are qualified, right? As you can see, they're qualified in the sense that they say, well, it has to be reasonable and it has to be safe. If it's not reasonable or safe, then you are not falling short when it comes to the question of whether are you allowing them to go back. So these regulations assist us because they are qualified and it has to be reasonable and safe. If it is not reasonable or safe, then obviously that obligation falls away. Now, an employee is also obliged to modify work areas, duties, and equipment or processes in accordance with injured persons in order to allow for this reasonable accommodation. Now, again, it goes back to the question of what should this new policy look like? How should this rehab policy look like? And again, it goes to, firstly, this is something new as well, is that it introduces what you call a health and wellness representative. And this health and wellness representative will act as a liaison officer between the fund, the injured person, and the rehab service providers, because there'll be certain instances where the rehab is done by an external service provider. Now, you need to ensure that your policy introduces such health and wellness representatives. And secondly, this policy needs to exactly line out or make it clear how the implementation of the return to work plan will be implemented and who will be responsible for such plan. And then it should also include aspects relating to how do you report injuries and liaise with disability case managers. In principle, it's just there to show employers how exactly they can benefit from what the government is trying to assist them in, and that will be the purpose of that policy once the act is in effect. Now, another question that you're probably thinking of, which you should be thinking of, is should the return to work program or the rehab fail or not yield any successful results, what can an employer do? Now, this goes back to the capacity of the employee to do their job. Now, remember what I mentioned in the beginning. The goal is to retain and to bring back the employee back into the workforce. If it doesn't happen, there are measures that can be taken. Now, Regulation 8F of these regulations state that the employer must notify the compensation commissioner in the prescribed manner about the inability to presume duty or the inability of the employee to return after all efforts have been made to preserve the employment of the injured employee. Now, should the rehabilitation and reintegration not yield successful results, then the employer has the obligation to then notify the compensation commissioner. And one thing that I should add there as a passing remark is that it even creates, these regulations create much more onerous reporting measures in terms that the reports that are derived from this rehab and reintegration are to be kept by the employer for a period of not less than 40 years. And that'll be something that will be important to consider considering POPI. However, this complies with Section 12 and 13 of POPI, as it will be information that is processed for a lawful reason. Now, the question, can an employee then dismiss the employee then after this rehabilitation and reintegration has failed or has not yielded successful results? Now, as to the question of yes, as to the question of can they, the answer is yes. However, the employer must, I'll repeat this, the employer must report such dismissal and its reasons to the Chief Inspectorate and the Compensation Fund in writing. Now, one thing that we've recognized or just noticed is that there isn't any, it doesn't say anything further about whether there would be any challenge to such a dismissal or if there's any process which will be taken after you inform the Chief Inspectorate of such a dismissal. Right? So maybe we'll see more regulations being developed in relation to that. However, what remains is that you do have to inform the Chief Inspectorate and the Compensation Fund when you dismiss such a person. Another important thing or question is, now, can you then go ahead and alter the terms and conditions of employment, right? Again, this goes back to you still need to inform the Chief Inspectorate and the Compensation Fund in writing when you do that. Now, as you know, item 10 of the Code of Good Practice requires particular consideration to be given to employees who are injured at work or who are incapacitated by work-related illnesses. And as we've seen in our South African courts, that they've held that the duty on the employer to accommodate the incapacity of an employee is more onerous in instances where they were injured at work. Now, let me just wrap up that little section for us. What are some of these practical considerations? If these draft regulations are passed as they are, employers will have to adapt their incapacity policies and procedures to, number one, create a rehabilitation program in an effort to return the employees to work. And number two, to facilitate the rehabilitation of such employees. Now, employers may not dismiss or alter the terms and conditions of employment of persons who are occupationally injured before first facilitating the rehab and reintegration to work process. You have to facilitate that process first. And secondly, you need to report the outcome to the chief inspector and the compensation fund in writing. Now, what I just want to look at before then I hand over to my colleague, Baron Madisa, I want to look at now who bears the costs of such rehabilitation. Now, the regulations are also clear in this, in that they state that the costs for the clinical and social rehabilitation and the costs for the assistive devices and the assistive technologies that are used in rehabilitation for previously employed employees with permanent disabilities will be borne by the compensation fund. Now, this includes the cost of supplying such assistive devices, the repairing of such assistive devices, and just the general technology that is needed as long as they need it. Now, that will be borne by the fund. Now, secondly, the costs of the vocational rehabilitation for employees who have already returned to work. Now, these are your employees that were injured but are now back at work, and you're trying to reintegrate them back into your workplace. Those costs shall be borne by the employer. Now, these costs include the cost of reasonable accommodation. Maybe this includes the adapting of your workplace to reasonably accommodate this employee. This cost, or these costs, are to be borne by the employer. And these are some of those aspects that have to be included in your policy as you consider same. Now, are employees to be remunerated during this rehabilitation period? And the answer to that is yes. The employees undergoing rehabilitation shall be entitled to compensation benefits payable under COIDA. So again, it doesn't put that on the employer, but to the compensation fund. And lastly, what are the penalties that may be imposed on an employer that does not comply with these? All the regulations say is that an employer who fails to comply with the provisions of these regulations shall be liable to a fine or a penalty as determined by the commissioner. So it doesn't set out the exact figures as to what those fines or penalties will be. So yes, without further ado, I'd just like to hand over to my colleague, Baron Madisa, who will be taking us through a case and looking at how this could have been implemented if it was passed then. Thank you.
Thank you very much, Kodiso. Good morning, everyone. So as my colleague Kodiso has stated, my main focus will be on a specific case. So I will be focusing on the obligations of the employer to an employee who gets physically injured because of training during the course of their employment. And I will do so by looking at the Constitutional Court judgment in Damons versus the City of Cape Town. Now, this case dealt with a number of issues, but my focus will be mainly on the concept of reasonable accommodation. This case also dealt with the consideration of policies that the employer would already be implementing in cases relating to incapacity due to injury. Furthermore, this case also, I think, ties in nicely with the issue of compensation for employees who are injured during work-related training, which is a topic I will touch on after discussing this case. So in the case of Damons versus City of Cape Town, the facts briefly are that in 2010, while Mr. Damons was employed by the City of Cape Town as a firefighter, he was injured during a fire drill, right? And the cause of the injury was that the officer who was in charge of the drill had disregarded safety measures during that drill. So as a result, that incident left Mr. Damons permanently disabled and unable to undertake any strenuous physical activities, right? And how the injury happened, or the safety measures that had been ignored by the officer in charge, was that Mr. Damons fell from the second floor to the first floor while being carried on the back of one of his colleagues. However, the safety measure that was in place and that should have been followed was that they were supposed to use props and not actually carry each other. So as a result of this, Mr. Damons became permanently disabled and could no longer meet the physical requirements of being an operational firefighter. Now, what had happened is that in 2009, a year before Mr. Damons was injured, the City of Cape Town had introduced a new policy that would be applicable to operational firefighters. Now, in 2010, following his injury, Mr. Damons then applied for promotion to the position of senior firefighter. However, he was not promoted because of his disability, because he was not able to complete the physical assessment. Now, a few years later in 2013, following incapacity hearings, Mr. Damons was then transferred to an alternative employment where he was doing administrative and educational work. However, he retained his salary as well as his title of firefighter. In 2014, following another unsuccessful application to the position of senior firefighter, Mr. Damons then approached the Labor Court, right? And I'm not going to spend a lot of time on what the Labor Court had to say, but briefly, the Labor Court found that in applying the policy to Mr. Damons in a way that prevented him from advancing because of his disability, amounted to unfair discrimination in terms of Section 6(1) of the Employment Equity Act. The Labor Court, however, acknowledged that the defense that was raised by the City of Cape Town, being that physical activity is an inherent requirement of the job of a firefighter, was a complete defense to any allegation of unfair discrimination. However, the Labor Court took it a bit further and held that Mr. Damons' issue was a bit wider than just an attack on the inherent requirement of the job. It then concluded that the City of Cape Town had not met its honors of establishing that the dismissal, that the non-promotion of Mr. Damons was for a fair reason. The matter then went to the Labour Appeal Court, and the Labour Appeal Court was very strict in their approach because they only focused on the City of Cape Town's defense of the inherent requirement of the job and resisted Mr. Damons' claim for advancement due to the position of senior firefighter. The Labour Appeal Court therefore overturned the Labour Court judgment and held that to the extent that there is a differentiation between Mr. Damons and other active firefighters who are considered for promotion. It was justified both by the operational requirements contained in the policy as well as the inherent requirements for the job of a senior firefighter, which would require that physical component. Now, the matter then proceeded to the Constitutional Court. Now, in the Constitutional Court, there were two judgments. There was a minority as well as a majority judgment. Now, in the Constitutional Court, Mr. Damons required the court to answer the question whether there was any justification for refusing him opportunities of promotion based on his disability, when in fact the injury he had sustained was occasioned by the city of Cape Town, as I've mentioned, through that officer who was in charge of the drill not following the safety procedures. He argued that the city of Cape Town was discriminating against him unfairly by refusing to waive that physical fitness requirement. The city of Cape Town again used or relied on the defense that, well, we can't waive the physical fitness requirement because it is an inherent requirement of the job of being a firefighter, and that this defense absolves it from any duty to reasonably accommodate Mr. Damons. Now, as I've already stated, there was a minority as well as a majority judgment, right? The minority judgment rejected the Labour Appeal Court's decision for setting aside the Labour Court order, which had directed the city of Cape Town to consider Mr. Damons for promotion. The minority held that the principle of reasonable accommodation imposes a positive duty on the city of Cape Town to explore ways of accommodating Mr. Damons beyond his current position. The minority therefore found that the defense of inherent requirement of a job was justifiable for not promoting Mr. Damons to the position of an active firefighter, but it was unjustifiable as a defense against its positive duty to reasonably accommodate Mr. Damons in other lines of employment, especially as the city of Cape Town was responsible for the incident that resulted in the injury and permanent disability of Mr. Damons. Now, the majority took a different view. What the majority held, and they disagreed with the minority judgment on the outcome and the underlying reasons. The majority cautioned that the use of reasoning which attempts to persuade based on evoking feelings of sympathy is irrelevant to the question, the legal question that they had to decide on. The majority held that the only question of relevance was whether the policy discriminated unfairly against Mr. Damons. Now, on the principle of reasonable accommodation, it found that the obligation to reasonably accommodate would only apply if such reasonable accommodation would make it possible for the employee to fulfill the inherent requirement of the job. And here the majority was clear that it must be for a specific job and not just any job. So when you are speaking of reasonable accommodation, you are looking at a specific job and the requirements of that specific job. So if you can reasonably accommodate based on that, then you are not required to now accommodate an employee on any other job. The majority held that any accommodation that would be beyond this would cease to be reasonable because it would effectively require an employer to employ someone who cannot possibly perform the inherent requirements of the job, or even worse, what this might do, it might then place an obligation on employers to basically create new positions in order to accommodate employees who do not meet the inherent requirements of a specific job altogether. Now, it held that once the city of Cape Town had successfully raised the defense that physical fitness is an inherent requirement of the job of a senior firefighter, the question of reasonable accommodation then fell away, because that inherent requirement of the job defense is a complete defense to the claim of unfair discrimination. Now, the court then, the majority then said that Section 62A of the Employment Equity Act would thus not be available to Mr. Damons, since at most it would require the city of Cape Town to reasonably accommodate him. The majority thus upheld the city of Cape Town's Section 62B of the Employment Equity Act defense, and the appeal was dismissed. Now, the reason I decided to deal with this interesting case, and as I've already mentioned, it does cover a few of the aspects that we've been discussing this morning. Now, my colleague Khodiso has already spoken to the regulation in relation to injured employees, right? And the prescription is that where you have a person who is undergoing rehabilitation and you now want to take a decision to dismiss them for incapacity, you do not simply take that decision to dismiss them. There is a duty or an obligation on you to inform the Chief Inspectorate as well as the fund in writing of your intention to do so. So it is important for employers to then ensure that they comply with these regulations when they dismiss an employee for incapacity. Now, another important point that I want to link this case to is Section 25 of the COIDA Amendment, which provides for compensation to employees who had accidents during training or performance of emergency services while undergoing any work-related training in the furtherance and pursuance of the employer's business. Now, earlier on, Fiona touched on this section. Now, if we look at the city of Cape Town versus Damons, the facts in that case, it's clear that in this case, there is no doubt about whether or not Mr. Damons was an employee. So if you look at that, it would mean that Mr. Damons, who was injured during a work-related training, which was that fire drill that I spoke to earlier, such an employee would then be entitled to compensation. So this is another provision that employers need to be aware of and be conscious of its implications. And in conclusion, I just want to say what is evident is that employers, through these draft regulations, will have the responsibility of ensuring that the facilitation of injured employees back into the workplace. This is done through a host of requirements that employers will have to implement to ensure compliance. And Khodiso and Fiona have already spoken about those compliance measures earlier. And these requirements will require a careful consideration before being applied to the business. Thank you very much. That was my part of the section.
Thank you very much indeed for all of you for attending this first part of our seminar dealing with the Occupational Health and Safety Act, COIDA, and of course we will be covering aspects for Mine Health and Safety Act as well. The purpose of this particular seminar was certainly to get you thinking and to get you to start asking questions. We've had some interesting ones in our chat box this morning, and what we'd like to do is answer those by way of a particular brief that we will be issuing as a department, where we'll tackle some of the aspects you've raised. And I'll give you one simple one which does get one's thought process going, and that is the employer has a bereavement policy with its employees. There's an accident at the workplace, a colleague loses his life, and transport is laid on for the funeral by the employer. Would that come under a claim for COIDA if during the course of that transportation to the funeral and or back an accident occurs? And really the question would be answered in the case of Daneka, which is a matter which also went to the Supreme Court of Appeals involving the Department of Health. You've got to look at whether or not there's a causal connection that occurs between that road accident and, of course, the employment relationship. Importantly, is this an incident that's necessary or incidental to the risk that was undertaken? If it doesn't fall under COIDA, it's going to be RAF. But I think that there could be an argument to suggest, well, why shouldn't it fall under COIDA if, in fact, this is part and parcel of an extension of employment functions in this scenario? Very interesting question that's been raised. The provision of transport on another question related to what happens then if the transport to and from the pickup point to the workplace is provided by a contractor, a third party. Well, the act or the amendments are clear, it would fall under COIDA. But there's some other interesting questions. As I said, we'd like to deal with it on that basis so that you've had the full benefit of our presentation this morning. And thank you very much for your attendance.